Hi, everybody. Lawyer Autumn Witt-Boyd here with this week's installment of the Legal Roadmap podcast and Facebook Live episode. This is episode 99. I can't believe that we are almost at 100 episodes. It has been almost 3 years that we have been doing the Legal Roadmap podcast, and it has really flown by, even doing them in seasons and taking some short breaks. It's just hard to believe that we're almost at 100, and I have something really special planned for episode 100, so stay tuned to the end. I will give you a sneak peek of what that is going to be all about. But in today's episode, we are going to dig into my very favorite topic, which is copyrights. So we're going to be continuing with this series for course creators. This whole season, season 4, is all about legal for course creators. So I am really going to focus on what course creators need to know about copyrights for their business, how they can protect their content using copyrights. And we're not going to get into copycats in this episode, but there will be further episodes about copycats and also about what we call fair use, or using other people's copyrighted materials in your course. So stay tuned for those. We're going to have lots and lots of good content on copyrights in this season 4 of the Legal Roadmap podcast. Before I dive in, I want to give my standard disclaimer, which is that I am a lawyer. I am not your lawyer unless we decide to work together one-on-one by signing an engagement agreement. So everything in today's episode is just meant to be information. This is not legal advice. Everything that we're going to talk about today, the nice thing about copyrights is that they are federal. So federal laws, that means they are the same in all 50 states. So you've probably heard me say I am licensed to practice law in Tennessee, but copyright law is exactly the same in all 50 states. So no matter where you are located, this information will apply to your business if you're in the United States or wanting information about United States copyrights. So I want to give you a little background before I dive in. I know I don't talk much about myself on the podcast, but I wanted to give you just a little bit of history and why I am so passionate about copyrights and why this is my favorite topic. So before I started my own law firm back in 2015, 4 years ago, I was actually a copyright lawyer. So I spent all day, every day immersed in copyright law. I worked for a small boutique law firm. It's called Harmon and Seidman. It still exists. And we were pretty much, or that firm, I considered myself a part of it, is the premier copyright infringement law firm in the United States. So they represent primarily photographers who own a lot of copyrights in the photographs that they have created. And they file lawsuits on behalf of those photographers and stock photography agencies for against companies who are using their images without permission. So for about 7 years, I worked for that law firm, and we filed lawsuits all over the country on behalf of our clients, the photographers and the stock photography agencies, going after people who had, in most instances, they had gotten a license, so that means permission. They had paid a fee for permission to use the images, but in most cases, they were kind of ignoring the terms of the license. A license is a contract, and so most licenses have terms that limit what you can do once you get the license. So it's typically a limited permission to use an image or a song or some other copyrighted work in a specific way. So we filed lawsuits all over the country. So I was in and out of the copyright law and helping my clients on copyright issues every single day. And it was really fun. It was challenging. Copyright law is very complex. It is not an easy area of the law, to be sure. So I learned a lot. I feel like I really dug in, and being part of that law firm and working in that area, there's only a really small number of lawyers in the United States that do that work. And so it was a privilege, and it was really fun to be able to do that work. And so I wanted to give you that background of what my expertise is in copyright law, why you should listen to me, why I know what I'm talking about. And I now, as you've heard me say, now I advise my online business owner clients about these exact same issues. So the type of works that they're creating are a little different, but all of the issues are pretty much the same. So that is some background on my interest and expertise in copyrights before we dig in. So today, I know sometimes I tell you I'm going to tell you 5 things about this or 10 ways to do that. Today, I'm really just going to give you an overview on how and why it is really important to protect the copyrights in your online course materials if you are creating an online course or digital products. This is all the same, whether you are creating more of a course or more of a downloadable digital product like my contract templates. All of those same concepts apply. So I'm going to give you an overview today. And then, like I said, we're going to dig into issues about copycats and using other people's work in future episodes, because those are pretty big, meaty topics on their own. So today, let's start out by talking about probably the most frequent question that I get when with regard to copyrights is, what is the difference between a copyright and a trademark? So we're going to start out all using the same words so that we are all on the same page. So a copyright is going to protect things that we consider original works of authorship. Those are big legal words. What does that mean? So typically it's creative works. So think about photographs, like I was talking about before, music, movies, books, poems, anything that we think of as like a creative work, images. These are kind of the core subject matter of copyright. Now, when we look at the online business world, things look a little different. We think of all of the parts and pieces of an online course can be protected by copyright. So that's going to be things like your videos, if you have downloadable audio files that are part of your online course, if you have PowerPoints that you put together and use to outline the different concepts or the different things that you teach about in your course, maybe to give examples, all of that is protected by copyright. Your handouts, your worksheets, if you have guides or if you have an ebook, not a part of people's courses typically, but just to get your brain thinking about some other things in your business that may be protectable. If you have created from scratch, like an operations manual or checklists or things that you use in your business to make sure that you are doing things the same way every time, those are probably protected by copyright. Not in every instance. If it's just a checklist that says like, open the mail, file the mail in a filing cabinet, make a copy, scan, save in this folder. There does have to be a certain level of creativity for something to qualify as copyright, but all of those kinds of things, it could be more things in your business than just the things that we think of as super creative, like music or books. So most of the things that you're creating in your business, blog posts, any kind of creative content that you're creating, images, graphics, all of the kinds of things that we are posting on social media, even like a long social media post could be protected by copyright. So all of those things I want you to think about, those are protectable under copyright law in your online business. If you sell like a downloadable guide or things like that, as far as digital products go, those are probably also protected under copyright law. So that's all the stuff that we think about as copyrightable. The things that we think about as trademarks are a little different. So that is what we think of as a brand. So it's typically going to be something like a company name or a product name. It's things that you use to identify the source of a product or service. So think about the way I explain this to my kids is we were looking at a cereal box one day, and I'm always trying to explain to them what I do as a copyright and trademark lawyer, and it's not always that easy. They're 7. But we were looking at the cereal box, and they noticed that the logo of the cereal that we bought was the same on several different packages of cereal. And so they were asking me about that, and I was like, teaching moment. So the logo helps you identify when you're in the cereal aisle, that comes from Kellogg's, or that comes from, I'm trying to think of another cereal brand. We buy a lot of store brands, so like the Great Value brand from Walmart, or, there's lots of different brands. So any of those kinds of things, they identify a brand. They let you know what company it comes from, things that tell you what kind of quality to expect in your in products or services. Those are going to be trademarks. So it's not only a logo, a company name, a product name. It could be something like product packaging. It could be a slogan or a tagline. So some of my favorite examples of this are the Coca-Cola logo is a registered trademark. The name Coca-Cola is a registered trademark. The shape of the bottle of Coca-Cola is a registered trademark, because when you see that on the shelf, you know what you're going to get. So trademarks are really intended to tell the customer that this is what you're going to get, that you know what you're expecting because you've either bought it before or you've seen an advertisement, or you know what kind of quality you're going to get. Trademarks are also intended to prevent customer confusion. So that's why you can't have too many companies using the exact same trademark if you're selling the exact same products and services. So think about copyrights as protecting creative works. Think about trademarks as protecting a brand or the identifier of a service or a product. Now, there can be some overlap between these, and an example that I will often use for this is Disney. So Disney is a registered trademark, the company name. The logo is registered. It has that very recognizable font that they use. That is a registered trademark. The word Disney in that font is a registered trademark. But also Mickey Mouse is a registered trademark because they use Mickey Mouse as an identifier of the Disney brand. Now, Mickey Mouse is also a creative character. He is, a drawn cartoon. So he also qualifies for copyright protection because it is a creative work. So you can see there's some overlap, and some things, especially with more image-based trademarks like logos and other design elements, we will sometimes protect them under copyright and trademark, or we may decide on one and not the other for different strategic reasons. But that should give you at least enough of a background, the difference between copyrights and trademarks and the little bit of overlap that we do see between them. So today, I'm just going to be talking about copyrights. We will have a whole series about trademarks too, don't worry. And if you are curious about trademarks, I've done many episodes. So just type trademark into your search bar wherever you're listening to this podcast, and you will come up with lots and lots of good episodes on trademarks. And we're going to have more that are really specific to online course creators later this season. So stay tuned. All right, so let's talk about kind of some basic elements of copyrights and how they could apply to your course and how you can protect them in your course. So as I mentioned, copyright is going to protect original works of authorship. So it has to be original to you. You have to be creating it. You can't just copy somebody else's stuff and throw it in your course and then protect it under copyright. It has to be something you're coming up with. It does not protect facts or ideas. And this is a really tricky area. I get this a lot when people tell me that they have like a method or a program, a way that they help their clients achieve something, or that they transform, A to B in their business. And that's part of their online course or part of their digital products. Copyright law does not stop someone else from basically having the same method or taking someone through that same transformation from place A to place B. You cannot protect ideas. You cannot protect facts. What you can protect under copyright law is the particular way that you express those ideas or those facts. So if you, if you write a book that tells people how to go through this 7-step process, then you can protect the book. But just a list of 7 things is probably not going to be protectable under copyright law. If you use graphs and diagrams to take facts and put them into a visual format that makes them make sense, or that shows, something special about them, that image could be protectable, but the actual facts that are in the chart or in the data are probably not protectable. This can be really important too. I get a lot of questions about using other people's work. Like, let's say, and I joke that there's no original ideas anymore. We're all building on other people's work. But especially with my clients who maybe are in the counseling space. And so they've read other people's work. They have maybe had a mentor that has taught them particular ways to work with clients. None of us are coming up with this stuff from scratch. And so, of course, we're all building on what we've learned from others. And again, I'm going to talk about that in a future episode. But just to be aware, copyright is only going to protect your original works of authorship. So it may be okay to take some ideas that you've learned about from someone else. And as long as you are writing it in your own words, or you're explaining it in your own words, you're making your own video or your own worksheets, that is your original work of authorship. So that could still be protected by copyright. You're just taking ideas that probably lots and lots of people are talking about in your industry or in your particular area. But you're putting it in your own words. You're putting your own spin on it. You are doing the design work. You're not just copying. You're doing your own expression. That is what is protectable. But you can't stop someone else from taking those same ideas and putting their own spin on it. That is not protectable. Copyright is what we call a bundle of rights. So what do you get with a copyright? You get several different rights. You get the right to use the work, so you can use it. You get the right to distribute it, so to send it out into the world, to make copies of it, to sell those copies, to put them online. You get the right to let other people use it. If it's like a play or a song, there's what's called a public performance right. So you get the right to control how other people perform your work publicly. And you get the right to create what we call derivative works. So those are other works based on your original work. So we see this a lot of times with, several editions of a book. The later editions are what we would call a derivative work. Or let's say you create kind of a fantasy world with characters, and you write a story about those characters, and then you write news stories about those same characters, building on that world that you created in the first book. Those are also going to be considered derivative works. So you as the copyright holder not only have the right to use the exact work that you're making, but also to create new works based on your original work. And just for some vocabulary, when I talk about infringement, this may be a word that you have heard, that just means use without permission. So if I say you have infringed my copyrights or you are guilty of copyright infringement, that just means you've used my copyrighted work and I did not say it was okay. You've used it without permission. All right, let's scroll down to how do you actually get a copyright? So you may have heard that in the United States, we have automatic copyright protection. So that's fabulous, right? As soon as you create a work, as soon as it's, I say, out of your brain and onto paper or into a computer file, as you record something on audio or you record a video, it can even be handwritten on paper. As soon as it's out of your brain and onto some kind of, it has to be a tangible medium, could be a computer file. It doesn't have to be, physically tangible. Congratulations, you now have a copyrighted work. It is automatic from the moment of creation. You don't have to do anything to get that copyright protection. It's pretty amazing. But here is the catch. You've probably heard people talking about registering their copyrights, and that means you file some paperwork with the United States Copyright Office. It is optional, so it's not required. You could have that automatic protection, and you do own the copyrights. You can send someone a cease and desist letter. But the catch is you cannot file a lawsuit in the United States until you have a copyright registration in your hand. I was trying to see if I have one handy. I have a trademark certificate behind me, but I don't have a copyright certificate. So you have to actually have that certificate in your hands. It's not enough to have filed the paperwork with the Copyright Office. And I've got some news for you. It can take 9 months or longer to get a copyright registration certificate. So to file a lawsuit, you have to have that copyright certificate before you can file a lawsuit. So copyright registration is optional if you just want to have the rights, but if you ever want to enforce your rights, if you ever want to send a cease and desist letter and be able to threaten someone with a lawsuit, which is really how we generally get people to stop using our work without permission, we tell them what will happen if they don't stop. We threaten them with something they don't want to happen. We tell them we will sue them if they don't stop using our work. Anyone who receives a letter like that and knows that you don't have a copyright registration, they know it's basically a hollow threat, that you can't actually follow up on it. You are a dog that is all bark and no bite because you can't actually take them to court until you have that certificate. So it's absolutely critical that you register your copyrights if you ever want to be able to enforce them, if you ever want to tell someone to stop using your work and be able to actually, I'm using all kinds of metaphors, put your money where your mouth is. You have to have that registration certificate. The other nice thing about registering, and there's an incentive to do it early, again, not required, it's optional, but it's a great idea. And this is the way that the Copyright Office, or the Copyright Act, really, the federal statute, kind of sweetens the pot. So they know that it takes a little work to register your copyrights, and it takes a little money. It's not super expensive, and I'll go through the process in a bit. But they know that it does take effort to register your works, especially if you are a prolific creator, if you are writing lots of songs, or if you're a photographer, you could go out and shoot for an hour or two and come back with thousands of images. It's not that easy to register your copyrights if you are, creating lots and lots of stuff. So they sweeten the pot with some extra benefits if you register early. So if you register your copyrights before you get copied, before someone copies your stuff without permission, before infringement, you get what are called statutory damages. And that is just a big word for you get a lot more money from the court. The court will force the infringer to give you a lot more damages. And it is up to $150,000 per work. So let's say you have a blog and it's got, maybe 10 or 15 images for a single post, and someone copies 3 or 4 of the images. So that's 3 or 4 times 150,000. It's per work. that you can get in damages. It's not guaranteed that you'll get that much. That's the maximum. But that is a pretty nice amount of money when you multiply it by, typically copyright infringement is not going to be just one work. Typically people are taking several things at one time if they're copying you, especially with an online course. You could have all kinds of different works included in an online course. So the ability to get statutory damages versus having to prove your actual damages, which is typically going to be the amount you would have charged someone if they had asked for permission. Typically that's going to be a couple $1,000s, maybe. So that's a pretty big spread from a couple $1,000s to $150,000 per work. So that's your number one sweeten the pot for registering your copyrights early. If you register after you've already been copied, you can still file a lawsuit. You can still get some damages, but you're going to have to prove them. You're going to have to prove what you would have charged. What would that license fee have been? And then you can also get any profits that you lost or profits that the other person made. But again, typically with most infringers, this is not going to be millions and millions of dollars. It's going to be a very small amount. So the second thing that you get if you register early is you can actually ask the court to make the infringer, so the person who's copied your stuff, you can ask them to pay your attorney's fees as part of their penalty for using your stuff without permission. So now we've kind of switched the economics of having to file a lawsuit. It's very expensive to file a copyright lawsuit. We're talking probably $10,000 to $20,000 to get started. They have to be filed in federal court. It's very expensive to file. You have to hire an experienced attorney. Not just any attorney is going to be willing to file a copyright registration or a copyright infringement lawsuit because it's a very specific, tricky area of the law. If you get all the way to trial, it would be very easy to spend $100,000, $500,000, $1 million in. When I was litigating at my old law firm, we would see the bills from the companies that we were suing, and if cases went to trial, it was well over $1 million in legal fees. So it is incredibly expensive. So the ability to flip that and say, if I win, you are going to have to pay my attorney's fees. It makes it much easier for you to actually go to court. Now, you're going to have to pay that money up front to your attorney, but the ability to know that you could recoup that on the back end makes it much easier, much more worthwhile to go to court to actually sue someone for copyright infringement. Just makes the economics much more bearable. So those are your two big benefits from registering your copyrights, especially early. You're going to be able to get much higher damages, what we call statutory damages, and you're going to be able to get your attorney's fees. In addition to the fact that you can't file a lawsuit at all. And if someone receives your cease and desist letter, they're going to know that you can't be serious because you can't actually file a lawsuit. So the incentives are built into the system that registration is optional, but it's really pretty much mandatory if you want to actually protect your works. So I highly recommend that if you have not already registered the copyrights in the things that you're selling in your business, especially your big sellers, you might not have to register. Let's say if you've got 4 or 5 different courses that you sell, you might not want to register the copyrights in all of them if it is too much time and trouble and money to do so. But especially in the ones where you're really making your money, it is very worthwhile to go ahead and register those copyrights. I call myself a copyright evangelist because I think everyone should be registering their copyrights. It's so important to be able to enforce your rights. Okay, so that's a little bit about, you get automatic protection, but you have to register to actually be able to enforce your rights. Next, I'm going to talk a little bit about who owns the copyrights in a work. It seems like it would be easy if I create something, I own all the copyrights, but it can be a little bit trickier than that. Because typically with an online course or with digital products, it's a business that is actually creating them. I may be Autumn Whit Boyd sitting at a desk, but I have a business. The Law Office of Autumn Whit Boyd PLLC is my business. It is a company. And we have several employees. I have an assistant, the fabulous Sarah Kate, who creates a lot of content for our law firm. She is actually the one in Canva creating those beautiful graphics that you see, and she helps me write our show notes and send out our emails. She does a lot of writing and creative work for my company. I'm guessing that a lot of you have either a VA or maybe someone who helps you with graphics or with copywriting or helps you put together your course. I've talked about in a previous episode about working with independent contractors and why it is so important that we use an independent contractor agreement. And this is part of that reason. It is that if you are working with independent contractors in your business and you want the business to own the copyrights and what they're working on, that is not possible unless you have it in writing. If the independent contractor does not agree in writing that your business owns all the copyrights, guess what? Under our copyright law, the default rule is that the independent contractor actually owns all the copyrights and all that stuff. So you've got to get it in writing. It is not enough to have it in an email. It has to be in writing and signed. Our copyright law is from the 70s, so it is not yet caught up to the way that most of us are doing business now. It's absolutely critical. If you want to own the rights in the things that your contractors are creating, you have to have it in writing, either what's called a work for hire term or in an assignment. So kind of two ways to do that. Again, I'm not going to dig too deep into the difference between those, but if you need an independent contractor agreement, I will give you a shameless plug. We do sell those in my online template store at awbfirm.com. You can get a really solid agreement for not a lot of money and get these rights all lined up. That's also part of our online course bundle, which we call the Legal Roadmap for Course Creators, where you get 5 contract templates, pretty much everything you need for your online course business. That independent contractor agreement is included in that as well. So if you are working with contractors, you need to make sure that you get those rights. If you have employees in your business, like real employees, W-2, you're paying them, they're on payroll, you're paying their taxes, the business will own the copyrights in anything that they create. And if you are the owner of the business, typically the business will own whatever you create, whether you pay yourself as an employee or not. If you're still a sole proprietorship, that business can still be listed as the owner of the copyrights. And typically, I will do that for most of my business clients, unless there's a good reason for the individual to be the owner of the copyrights. Like some authors prefer to own the copyrights in their individual name rather than in the company name. That's a more advanced issue that you're definitely going to want to talk about with a lawyer if you are not wanting the company to own the copyrights. There may be good reasons to do that. Some of my clients who are at a higher level, who are, in the mid 7 to 8 figures, will have even a separate company that just holds the intellectual property. You may have heard of an IP holding company, that's a separate entity that just owns the intellectual property. Again, that is a very advanced way to set things up. So you are definitely going to want to be working with an experienced attorney if you are thinking about doing something like that. But you know me, I like to plant seeds so that even if you are not there yet in your business, if you have dreams or plans or goals of getting there, I want you to know that some of these are things that are possible. But typically, if you are newer in business, if you are either a sole proprietor or you've set up an LLC, typically the business will want to own all those copyrights. So if you are the owner or an individual working in that business as an employee, the business automatically owns the copyrights to all of that stuff. So, which is really nice. That's typically how we want it to work. So under our copyright law, the person who creates the work is called the author, and they are the initial owner of the copyrights, but they can be transferred. So like I mentioned with independent contractors, or if you are collaborating with another company, or maybe you hire another company and you want to transfer the copyrights, that is very doable. We do that in what's called an assignment agreement. So it just, again, it has to be in writing, it has to be signed, it can't be in an email. You can transfer those rights. Now, another interesting issue that comes up with authorship or ownership of copyrights is, what if you collaborate with someone? So let's say I have a friend who is maybe a CPA, and we decide we're going to put together an online course that's everything you need to know about legal and tax for an online business. And we're collaborating. She creates some of it, I create some of it. We each have kind of independent parts, but some of it we do together, and we're writing, we're sending drafts back and forth, and it's very collaborative, so it really does become one work. Well, guess what? This is another kind of default rule in copyright that we don't always know about. We are co-authors, and we both own the work, so the work as a whole. If it is kind of one whole work, and it's not just, oh, I had this module and she had this module. If we did do work together, so it's combined into one work, we are considered co-owners. And we both have the right to do whatever we want with that work. So that is not always what people want for the way Sorry, I'm losing my words. Not all co-authors or not all collaborators want things to work that way. So you may want to change that with a contract. Again, in writing and signed, not in an email. So some of these default rules can be changed. If you get them in writing, if you agree, you can change it. But I always like for you to know this is the way things are going to work if you don't change it. So be aware of co-ownership issues. And again, this is a tricky area of the law. So if you are collaborating on something, especially that's going to be a big moneymaker for your business or for their business, this is definitely an area where you want to bring in an expert to help you work through these issues and make sure that you have set things up to work the way that you actually want them to work. All right. So I mentioned before the rights that you get with a copyright. Generally the right to use the work, the right to keep others from using work. I mentioned derivative works, and I just wanted to give a plug. I'm going to talk about fair use, so that's using other people's work, in episode 107. So stay tuned for that. And also, way back in season 1, I did an episode on fair use, which is kind of more general. So episode 107 is going to be really specific to online courses. But if you want to learn about fair use, go listen to episode 8. That is in the archives, and you can go ahead and learn about fair use. You don't have to wait for episode 107. All right, the last thing I'm going to touch on is the copyright registration process. So if you've listened to previous episodes, you maybe have heard me talk about the trademark registration process, which is very complicated and very expensive. The good news is the copyright registration process is not nearly as complicated or difficult or expensive as the trademark process. So hallelujah for that. This is part of what makes it easy for me to be a copyright evangelist, because the copyright online form, it is an online form. You can go to copyright.gov and fill it out. It is not super duper easy or super duper simple, but you can probably figure it out. It is not that hard. And the nice thing about copyright law, which is again kind of the opposite of trademark law, is the law is very user friendly. So even if you make a mistake, if you check the wrong box or you put the wrong thing in the wrong square, it will be pretty generous to you unless you knew that you were doing it wrong and you did it on purpose to defraud the Copyright Office. Like you knew you wouldn't get a copyright registration if you filled it out the right way, and so you put the wrong information on purpose. As long as you're not doing that, and my guess is most of you are not going to be doing that, you will be forgiven. Your copyright registration will still stand. It will all be fine. I will say, if you are a business making a lot of money from your copyrighted works, hire an attorney. Make sure you get this done the right way, because if you do ever have to file a lawsuit, it will just kind of add a layer of complication that you don't need to the litigation. But if you are a smaller business, if you're just getting started, you can absolutely go ahead and file a copyright registration on your own. I would much rather that you have a copyright registration that maybe has a mistake here or there, but you have it, than wait because you're worried about not doing it the right way or not having enough money to hire a lawyer. So it's better done than done perfectly with copyright, for sure. Again, trademark is different. I don't recommend that people file their own trademark registration applications. It is adversarial. It is a tricky, difficult system. But copyright is fairly user-friendly. And it's also, the filing fees are not super expensive. So if you're a business filing a registration application, it's $55 per work. And if you are selling something as a bundle, so like, for example, I mentioned my legal bundle that I have for online course creators. That includes 5 templates, a video series to help you fill them out. It includes some other resources that I've put together, some handouts, some other guides about intellectual property for your business. I sell that as one thing. So I even though it's got lots of parts and pieces, I sell it as a package. So that is considered one work under our copyright law. So I can file a single trademark registration, and even though that is a ton of stuff, I can send it all into the Copyright Office, and it is all registered for one filing fee. And it's all part of one copyright registration. So that is a nice benefit. If you have a big online course, or even if you sell, maybe you have 10 online courses, but if you do offer like that you can purchase them all as a package, you could register all that stuff for one filing fee. So there are some ways to do this really economically. Again, that's $55. You can go online to copyright.gov. The website is pretty outdated. They're working on it. I actually met someone at a meetup recently who is part of the team working to update it. But it's not ready yet. But it is fairly easy. You can go through it yourself. And again, if you make a mistake, it's typically not the end of the world. So highly, 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 again, recommend that you start registering the copyrights in your work. The last thing I want to talk about is the copyright symbol. So you may have seen the C in a circle, and there is a lot of confusion about who can use that, how it should be used. So I will tell you, anyone, if you have a copyrighted work, you can use that C in a circle. It just means copyright. So it does not have to be registered. And that's, again, different from trademark. You can only use the R in a circle for trademarks if it's registered. With copyright, it's the same symbol, whether it's registered or not. And it's a great idea to use it. It is not required. You don't have to use it. Back prior to 1989, you actually did have to have a copyright notice on your works. You do not anymore. But it's a good idea, because what using that copyright notice does is it puts anybody who might think about using your work without permission, it lets them know, hey, I own this. I think that it's a copyrighted work, and you can also add words with your copyright notice like all rights reserved or no use without prior permission, or things like that. So it lets people know, hey, this is mine, I own it. So if they have questions, they know who to contact. You can put your business name or your name. That's a good idea. And it's also a good idea to put the year. So a typical copyright notice is going to have the C in a circle, the year that it was first published, and then the owner. So either the company name or an individual's name, depending on who the owner is. So what that does is it stops someone from later claiming, let's say you have to file a lawsuit because someone uses your stuff without permission. They can't claim that they had no idea it was a copyrighted work, that they are an innocent infringer, because it had the copyright notice on it. It was right there. It said it loud and clear. So I highly recommend that you put the copyright notice on everything that you are selling, on all your freebies, anything that, if you have a downloadable guide, people sign up for your email list and you send them a PDF guide as a thank you, you should be putting that copyright notice on everything. I put it in your PowerPoints if you're doing videos. Put it on, if you're using an online platform to host your course contents, like your videos and all your downloads and all your things, you can customize that so that it appears there. It should go on your worksheets. If you have a landing page where you send people to sign up for your program, you can put it there. If you're doing blog posts, you want to have it in your footer of your website, on all your blog posts. Again, you're just kind of putting people on notice. Hey, I created this stuff. I think I own the copyrights in it. And you can put, whether they have permission, whether they have, you can share it, but don't print it or whatever, if you have different rules. I like to just put, all rights reserved. So that basically means I'm keeping all these rights for myself. You don't get any. You cannot use this without my express permission. But the important thing to know is you do not have to have a copyright registration to use that C in a circle symbol. So go forth and start using your copyright notice. It is a very, very good idea. All right, I hope this was all helpful, and I'm guessing that it is probably spurring some questions. So if you have questions about copyrights for your online course or for digital products, please hop over to the Legal Roadmap Facebook group. You have to answer a couple questions. We just want to make sure that we're keeping it to business owners or people with business ideas. You don't have to have started yet. Answer a couple questions. We'll let you write in and you can post your questions there. I hop in and other people from the AWB firm team will hop in and answer questions, and other people in the group are super helpful as well. So you may have kind of a tricky situation that someone else has been through, and people are great about answering questions and being helpful in there. So again, that's the Legal Roadmap Podcast Facebook group. Go on over there and check it out. And we'll have all the resources that I mentioned during this episode in the show notes. As always, you can find those at awbfirm.com/podcast. And then the episode number, this is episode number 99. So awbfirm.com/podcast and then the number 99. I am so excited to be back with you next week for episode 100. Again, it is hard to believe that we are already there, but I am going to give you guys a bit of a different episode. So if you listen to my interview episodes, you know that I love to talk with business owners about their lessons learned, about things that might be helpful for someone else who's trying to build a similar business. So I am going to pull back the curtain a little bit on my own business and share some lessons that I've learned from being in business for 4 years, and a little bit of behind the scenes information about how I've built this business, some mistakes that I've made, some tips or pointers that I have, and these will not just be legal. So be sure to tune in. If you've ever been curious about how we run the AWB firm and my lessons learned along the way, episode 100 is where you will get to learn all of those things. I'm going to be I would say more honest. I'm pretty honest all the time, but kind of show you some behind the scenes stuff that I don't normally share. So get excited. That'll be episode 100 next week. Hope you guys are having a great summer, and I will talk to you soon.